This podcast covers tort law. Let's begin with a simple question. What is a tort? The word tort comes from the Latin tortus, which means twisted or wrong. A tort is a wrongful act committed by a person or an entity known as the tortfeasor, resulting in injury or loss to the victim. What is the remedy for a tort? A civil suit for damages. The parties to a tort suit are plaintiff, also known as the victim, and the defendant, also known as the tortfeasor. There are three types of torts: negligent acts or omissions, which means failure to exercise reasonable care and injury. Personal injury and medical malpractice qualify under this. Examples include negligent driving and injury, a physician incorrectly performing a procedure and an injury results. Another type of tort are intentional acts. This occurs where someone acts wrongfully with intent. This can happen with assault and battery. For example, Albert punches Joe. False imprisonment qualifies under this category as well. So does defamation, trespass, and fraud. These acts all require intent. Strict liability is a third type of tort. This tort occurs where one is strictly liable regardless of his or her negligence or intent. It is essentially liability without fault. The law imputes strict liability to situations it considers inherently dangerous. One just must prove that the tort occurred and that the defendant was responsible. For example, the owner of a tiger rehabilitation center is an inherently dangerous situation. If an animal escapes and causes damage and injury, the owner is strictly liable. Even if it's proven that the tiger cages are the strongest ever made, strict liability results. Another example might be where a contractor hires a demolition subcontractor that lacks insurance. The subcontractor makes a mistake and causes damage. He might damage, for example, a car or adjacent property. The contractor is strictly liable for the damage. The situation is inherently dangerous, so plaintiff must prove that the tort occurred and the defendant is responsible. Negligence is the failure to exercise reasonable care. In order to prove a negligence case, the following is required. First, defendant owed plaintiff a legal duty of care. Second, defendant breached his legal duty of care. Third, plaintiff was injured, either his person or his property. Fourth, defendant's breach was the actual cause and also the proximate cause of plaintiff's loss. The legal duty of care, the first requirement to prove negligence, is a reasonable person standard. This is an objective standard. The reasonable person is not held to a perfect standard, but is held to exercise ordinary care that a reasonable person would exercise under the circumstances. For example, one who drives a car is held to the standard of care of a reasonable driver. Therefore, a nearsighted driver who forgets to wear her glasses and hits a pedestrian, has she committed negligence? Yes, she has. A reasonable, nearsighted driver would wear her glasses. What about this scenario? Dan is walking on a loading dock and tossing large bags of grains onto a truck. Two children are playing nearby, and Dan sees them. Dan throws a bag toward the truck and accidentally strikes a child. Is he negligent? Yes, Dan did not act reasonably when he tossed the grains near the children. Another example. You are driving the speed limit, but the car in front of you stops and you slam on your brakes. Despite your best effort, you hit the car in front of you. The driver of the car you hit states that you were negligent driving. What do they argue? Well, they argue a reasonable driver would leave enough space to stop in this type of situation. What about if the driver in front of you, if their brake lights are out? In that case, contributory negligence would likely apply, as you are slightly at fault. A reasonable, skilled physician. How would a reasonable doctor act in the same circumstances in a medical case? People with special skills are held to a higher standard, and that standard would be that of a reasonable physician, or in a legal case, that of a reasonable lawyer. In a medical case, let's say a patient consents to back surgery that is not medically necessary, but the physician does not disclose the risk that there is a 40% chance that paralysis could result. And in fact, paralysis does result. A reasonable person, knowing of the risks, would not have consented to such an operation. Yes, the doctor has breached his duty of care for failure to disclose the risk. A reasonably skilled physician would have done so. Let's discuss breach of duty of care, the second requirement to prove negligence. Negligence per se is a violation of laws designed to protect the plaintiff against the harm caused. Violating these laws creates a presumption of negligence. Negligence per se can commonly occur with traffic laws, building code regulations, and more. One example is you run a red light and hit plaintiff. Does plaintiff have an action for negligence? Yes. Your actions qualify as negligence per se, as you violated a traffic law designed to protect the public, including the plaintiff. Another example is a contractor builds a house but fails to use the minimum support for flooring required by law. Homeowners move into the house a week later, and while gathering in the kitchen, the floor gives way and the homeowners end up in the basement. Is this contractor liable, and under what theory? Yes, the contractor is liable. She is negligent per se. The law she violated is designed to protect the plaintiffs against the harm caused. Res ipsa loquitur. This is a Latin phrase which means the thing speaks for itself. Here, negligence is inferred from the simple fact that the injury occurred. Someone must have been negligent for this particular injury to occur. The classic example is the person who during an operation has her appendix removed, and then sometime after the operation, she still has pain in her stomach, revisits the doctor, and after an x-ray, she learns that the scalpel was left inside of her when she was sewn up. This is a clear case of res ipsa loquitur. There is no reason other than negligence that a doctor would sew a scalpel into somebody's stomach. So this would mean that if the patient were to sue the doctor or the hospital, all she would have to put into evidence was the fact that there was a scalpel sewn into her stomach. That alone would be enough to infer that there was negligence. Another example is a dead mouse found in a new soda bottle. There is absolutely no reason for a dead mouse to be in a soda bottle except that there was some negligence when the soda was packaged. A third example is when two trains collide because there is no good reason for the trains to be in the same place at the same time without negligence. The standards of care for professionals such as doctors, hospitals, dentists, lawyers, engineers, accountants, and mechanics is a reasonable standard of care for professionals with similar training and experience. The standard of care for real estate owners varies depending on one's status. An invitee is owed the highest standard of care. Invitees are generally people who come on land for a business purpose. An example is a customer in a store. The standard of care for an invitee is reasonable care for that specific person's safety and a duty to inspect and make conditions safe. If a shopper in a grocery store slips on a banana peel, she can argue the store was negligent because it did not create a safe environment for her to shop. A licensee is owed a lesser standard of care. One example are household guests. They are entitled to general reasonable care. If a friend is at your home and slips on your wet floor, can that friend successfully sue for negligence? Well, it depends. How long was the puddle there? What is reasonable? Unlike an invitee, there is no duty to inspect. What if the next time your friend falls on your broken step, a step that you knew was broken, but you were lazy about fixing it? This time, your friend would likely sue for negligence and win. A trespasser is owed the lowest standard of care. A trespasser is one who comes onto land without permission or privilege. The owner's duty is not to commit an intentional tort against her. Causation is the fourth requirement to prove negligence. Both actual cause and proximate or legal cause must be found. In order to prove actual cause, we look to the but-for test. But for defendant's actions, plaintiff would not have been injured. Proximate or legal cause must also be proven. This means proof that the plaintiff's injury was a reasonably foreseeable consequence of the defendant's act or omission. What exactly does this mean? The defendant is held liable only where the injury is reasonably foreseeable. The Palsgraf v. Long Island Railroad case was a landmark case which helped establish the concept of proximate cause. In that case, a passenger was carrying a package while hurrying to catch a train. The railroad's employee helped him into the car. The employee accidentally caused the man to drop his package he was holding. Unbeknownst to the employee, the package contained fireworks. The fireworks exploded, causing a scale some distance down the platform to fall. The scale injured bystander Palsgraf. Palsgraf sued the railroad, claiming her injury resulted from negligent acts of the railroad employee. Chief Judge Benjamin Cardozo discussed the concept of causation. He stated there was actual cause. But for the employee's conduct, Palsgraf would not have been injured. However, Judge Cardozo found there was no proximate causation. The injury was not foreseeable. The injury to Palsgraf was not a foreseeable result of the actions by the employees. There was no way the employee could have known that the package contained fireworks. Do you remember the hot coffee case we discussed with regard to punitive damages? This case is a great illustration of our next concept, vicarious liability. Vicarious liability occurs where a person or entity is held responsible for the tortious acts of another. Common examples occur with the following relationships: employer-employee, principal and agent, attorney and paralegal, and hospital and doctor. In these cases, the supervisory party can be held liable for the actions of the subordinate party based on the relationship between the two parties. One exception occurs where an employer is usually not responsible for the acts of an independent contractor. In the infamous hot coffee case, McDonald's, the corporation, was found vicariously liable for the franchisee's negligence. McDonald's had to pay the punitive damage award close to $3 million. Another example of vicarious liability might occur at an amusement park, where an employee forgets to attach a safety latch. The injured patron might sue the park under the theory the park is vicariously liable for the acts of its employee. What happens if there is an intervening act or someone after the defendant's negligent act causes plaintiff's injury? The defendant in that case might be protected from liability. This would mean that the intervening party is responsible unless that intervening act itself is foreseeable. For example, assume that a farmer agrees to store a large sculpture for an artist. The sculpture is designed for outdoor display, so the farmer leaves it in her backyard. A tornado throws the sculpture several thousand feet, ruining it. If the artist sues the farmer for damage to the sculpture, the farmer may argue that the tornado was unforeseeable and intervened between her negligent storage and the damage, thus relieving her from any liability. What types of damages are available to the plaintiff in a negligence case? First, we'll talk about compensatory damages. These damages make the person whole. They include lost wages, medical bills, and property damage, pain and suffering, loss of consortium to the injured spouse. Second, punitive damages may be available. These damages punish the defendant for gross negligence. They are awarded based upon the intentional failure to perform an act required by law or outrageous disregard of the rights of others. An example where punitive damages are likely to be awarded is a case involving an intoxicated driver who drives in the lane of oncoming traffic and causes an accident. Negligence affirmative defenses include assumption of the risk, contributory negligence, and comparative negligence. The first affirmative defense for negligence is assumption of the risk. This defense means that the plaintiff knew of the risk in using the product or service and consciously disregarded the risk of injury. One example is a case I worked on years ago as a law clerk at the Arizona Court of Appeals. In that case, an employee's finger was cut off while he operated a bottle-making machine. The employee had disabled a safety valve in order to make the process go faster, as this wasn't apparently what all of the employees had been encouraged to do in order to produce bottles at a fast rate. The employees sued for negligence, claiming the machine was defective. The employer defended that the employee assumed the risk when he disabled that safety valve. The result was the employee recovered damages, but the amount was reduced based on his apportionment of fault. An assumption of the risk can be explicit. For example, when you sign that waiver or release of liability to go skydiving, you explicitly assume the risk. An assumption of the risk can be implied. For example, if you attend a baseball game, you are impliedly assuming the risk to be hit by a baseball. Another affirmative defense, contributory negligence, occurs where plaintiff's own actions contribute to his injuries or losses. Contributory negligence is a total bar to recovery. So if the plaintiff is just 1% negligence, there is no recovery. Let's say there is a puddle in your home. Plaintiff was running when she slipped. Since the plaintiff was partially at fault, she can't recover. The lesson here is, if you happen to get injured, don't do so in a contributory negligent state. In the United States, pure contributory negligence only applies in Alabama, the District of Columbia, Maryland, North Carolina, and Virginia. Indiana applies pure contributory negligence to malpractice cases. Comparative negligence is a more equitable affirmative defense where plaintiff's own actions contributed to his injuries or losses. Here, unlike contributory negligence, there is an apportionment of fault. Damages are reduced by the plaintiff's percentage of fault. In a pure form jurisdiction, the plaintiff can recover regardless of the amount of her negligence. In a modified form jurisdiction, if plaintiff is 50% negligent, there is no recovery at all. Arizona is a comparative negligent state. So taking the example from above, where there is a puddle in your home, let's say plaintiff was running when she slipped. In a comparative negligent state, like Arizona, the plaintiff's damages will be reduced by the percentage plaintiff is at fault. We just discussed affirmative defenses for negligence. Now we are going to discuss general affirmative defenses. The first is that the court lacks jurisdiction, or the plaintiff is suing in the wrong court. This might happen if the injury happened in Florida, but the plaintiff brings a lawsuit in Arizona. The second defense is statute of limitations, or the plaintiff is suing too late. The third defense is standing. The plaintiff must have suffered a harm or have a legally protected interest. For example, if the plaintiff slips and falls but does not suffer any injury, she has no standing to sue. Let's move on to intentional torts. An intentional tort is defined as a willful act that a tortfeasor knows or is substantially certain will cause injury to another, interfere with another's property, injure a person's reputation, or wrongfully invade someone's privacy. One's harmful intent can be transferred from person to person under the transferred intent doctrine. Courts use the bad aim test. So if A attempts to harm B, but accidentally misses and harms C, A's harmful intent to harm B is transferred to C, thus rendering A guilty of intentionally harming C. Assault and battery are common intentional torts. Assault is defined as placing another person in reasonable apprehension or fear of injury or unwanted physical contact. This tort requires intent. Note that assault does not require any physical contact. For example, assault can occur with a missed punch. Battery is defined as physically injuring someone. This also requires intent. For example, striking someone with a baseball bat or throwing a stone and hitting someone are both battery. Assault and battery often occur together. An aggressor who threatens to beat up another person, this is the assault, and then proceeds to beat up the person, this is the battery. Note that assault and battery do not have to occur together. So a person who is struck from behind can sue for battery. However, in that case, there is no assault, as that person never apprehended or anticipated the strike, since he did not see it coming. False imprisonment is another intentional tort. It is defined as intentionally restraining a person's freedom or confining a person without that person's consent or without legal authority. A jailer who refuses to release a prisoner once that prisoner has served his term has likely committed false imprisonment. If security prevents a customer from leaving the store, the detention must be temporary where there is a reasonable basis to believe the customer has shoplifted. The customer must be detained in a reasonable manner. The fourth intentional tort is defamation. This is defined as communications that cause another person to be held in ridicule or that injure another's reputation or business interests. Defamation requires intent. The intent must be to publish, not the intent to defame. Examples include calling someone dishonest, corrupt, hypocritical, lazy, incompetent, criminal, unfaithful, or financially troubled. The statements must be false. What if the publisher did not intend the meaning? For example, a magazine jokingly described a gossip columnist as permanently pissed. Is this defamation? Yes. In that case, a jury felt this suggested the columnist was regularly drunk and awarded damages. So it doesn't matter if the publisher didn't intend the meaning. What matters is what ordinary readers or viewers will make of it. Imagine I wrote that Sam often visited brothels. I may be able to prove that it's true. Truth is a defense. Sam may visit brothels every day, making deliveries of wine. Is this defamation? Yes. The readers will read between the lines and gather that I'm saying that Sam frequently hires prostitutes. It may be quite defamatory, especially if Sam is married or strongly religious. Defamation includes what ordinary readers or viewers see or hear between the lines. So, what needs to be shown to prove publication? That the publication was conveyed to at least one other person. It does not have to have been published in a newspaper or broadcast. It doesn't need to have been recorded or written down. Slander is oral defamation. For example, telling others that your friend is a thief and it's not true. Libel is written or printed defamation. For example, writing that your friend is a thief and it's not true. In a defamation suit, one must usually prove financial loss, such as loss of a job, a prospective gift or inheritance, possibly a business relationship or customers. There are exceptions where financial loss need not be proven. And this is where there is a false statement of perjury, treason, criminal defense, loathsome disease, or sexual relations with a minor. Defamation generally does not apply to public officials and public figures, and a defense to defamation is truth. Intentional infliction of emotional distress requires that defendant's conduct is intentional or reckless. Defendant's conduct must offend generally accepted standards of decency or morality. Defendant's conduct must be causally connected with plaintiff's emotional distress. Finally, defendant's conduct must have caused plaintiff to suffer severe emotional distress, an element which is often difficult to prove. Interference with property includes trespass to land or property and nuisance. Trespass means going on another's land or property without permission. Nuisance is using one's own land in a way that affects another's land. An example is the unlawful diversion of water by a farmer upstream, which cuts off water access to a farmer downstream. Another example is burning debris on your land and smoke and fumes drift onto another's land. Fraud and misrepresentation require the following: a false statement of material fact, knowledge by the person making the statement that the representation is false, intent by the person making the statement that the representation will induce another to act, and justifiable reliance on the representation to the injury of the other party. A sale of a used car represented as brand new would meet all of these elements, and thus the salesperson would be liable for fraud and misrepresentation. Defenses to the intentional torts we just discussed include consent The plaintiff consented to defendant's actions. Consent can be express or implied. Another defense is self-defense. This can be defense of the self or a third person. A third defense is authority of law. A school teacher might keep a student after school for a reasonable period of time, and this might be her defense to a false imprisonment claim. Products liability cases are unique in that one need not prove a duty of care. Instead, one must prove the product is dangerously defective. Strict liability is imputed where the following factors apply. The defendant sells a defective product. The product is unreasonably dangerous to the user or consumer. The defendant is in the business of selling that product. The product has been substantially unchanged. The product causes physical harm to the user or consumer. For example, regarding the defective bottle making machine I spoke about earlier, the employee, while using it as trained, got his finger chopped off and sued the employer. Was the employer liable? Yes, the employer was strictly liable as all the factors of strict liability applied, including the machine was defective and unreasonably dangerous. Now, if the employee disabled the safety valve in order to make the work go faster, as he did, was the employer still liable? Yes, but the liability was reduced by the employee's percentage of fault. The product or bottle making machine had been changed, one of the factors of strict liability. The theory behind products liability is not caveat emptor, let the buyer beware. The rationale for strict liability is that it increases safety and sellers of goods should be responsible for defects, injuries, and losses. This concludes our podcast for torts.